since 1998 with jobs in housing associations, local government and national government, and he's been running his consultancy since 2011. We'll be hearing from him for about an hour with me asking questions during the presentation, and then we'll have a short comfort break at 12 before returning to hear from Mary Gagati about how Greater Manchester Combined Authority are working on allocations. So Mary Gagati is the Principal for Housing Strategy at Greater Manchester Combined Authority, and her role involves working in partnership with local authorities, housing providers, the NHS and other partners on the delivery of Greater Manchester Housing Strategy priorities. So without further ado, I will just hand over to Neil to start his presentation. Thanks.
Thanks, Becca, for the introduction. Thanks for everyone for joining. Very much pleased to see you all and looking forward to hearing your thoughts and views as we go through the presentation. If you just bear with me a minute while I sort out sharing my screen with you. Okay. So, social housing allocations and lettings, all about how housing associations can do this. There's going to be lots in this presentation. I'm sure the NatFed will make the presentation available to you after the event. And of course, as Becca said, it's been recorded, so you can always go back and replay your favourite bits. So, as Becca has said, I head up a management consultancy that specialises in public and social housing policy and practice. We were formed in 2011. We work across all England, Scotland and Wales. We get to see all different aspects of housing from the devolved nations. Alongside working with housing associations, we also work with local and national government and voluntary organisations. We do what we do because we believe there should be adequate housing for everyone, and we're quite passionate about that within the work we do. And what we do primarily, in a nutshell, is improve the quality and the potential of housing services and strategies. And we specialise in certain areas, allocations and lettings being one of them, but homelessness and housing advice being another, private sector housing, housing policy and strategy, and supported housing. Those are all the areas where we specialise in. We've worked with lots of housing associations all across England, Scotland and Wales, some big, some small, some many in England, some also in Scotland and Wales. So that's just an idea of the type of organisations we've worked with down the years. Today we've got four things I'm going to talk to you about. I'm going to give you some context behind allocations and lettings, so we're all kind of starting the discussion from the same point. Then we're going to delve into the legislation that relates to housing associations, and there's more of that than what you might imagine. Then we're going to look at what the regulator requires of you, and then we're going to touch on a few common matters that come up when we're doing day-to-day administration of allocations. So we're going to pack all of that in the next hour, and Becca's going to pop up every now and then with a question for me relating to what we're talking about to sort of tease out some more content. So let's start with the context. All of these fancy infographics I'm showing you here have all been produced and published by the Department for Levelling Up Housing and Communities. They publish an annual report on lettings, and the data we're using here is from the most recent period available, which extends from April 2021 to March 2022. This data was published in July of this year, so it's relatively new data. If anybody wants a link to where they can find this data and this report, then get in touch with me afterwards. The DLUC provide a really powerful analytic tool, as well as spreadsheets you can look at. They've got a really powerful analytical tool that you can do all kinds of analysis using all kinds of shortlisting options that then provide you with graphs and charts and more infographics. So there's lots and lots of evidence out there around what you're doing around allocations, and you can benchmark in all kinds of different ways with others to inform your whole practice around allocations, and also connected to that, all of your policy and practice around tenancy and the type of tenures you offer. This is a headline here really that shows us over the period of that year 2020 to 2021. We've got 246,000 properties that were allocated, of which by far and away the majority was by housing associations, and of all the allocations made that year, it represented 6% of the total social housing stock across the country. This has been fallen, of course, during compared to when levels peaked in 2013-14. So the actual number of allocations has fallen, as has therefore the proportion of stock being let. And of course, during this period, we've got the COVID-19 pandemic. So that's going to have some sort of impact on the number of properties that are being let during that period. Overall, there are 4 million households in social housing at this current time. We of course offer kind of all kinds of different rent products within the social sector, and what we can see though is that by far and away the majority of allocations are made on a social rent basis, which is the most common type of basis that we've seen historically and still continues to be so, with people being given a letting at an affordable rent rate being quite a relatively small minority of lettings made. And again, primarily people are given a general needs property when they're allocated somewhere. Just around about 3/4 of people are given that type of property, whereas the minority of people are given supported housing. So again, it just gives you a flavour of what's happening out there. Who's getting these lettings? Well, again, we can see that just over 56% of people are single adults, so more than half single adults being given an allocation. We can also see that there's a roughly equal mix of males and females, some variation at different ages, but there's roughly an equal mix of males and females. But what we see is there's a significant number of people at certain age groups, particularly in the 20s, and 30s, where we're seeing people with a quite a lot, representing a large proportion of the people.
Neil, just on that,
yes,
is there anything you can say about the makeup of households moving into social housing and how that's changed over time and how that relates to allocations?
Yeah, so historically, social housing was allocated more so to families. I mean, single people have always been given it, but there's been a much greater degree of families being allocated social housing, particularly post Second World War. And what we've seen, certainly in the last 20 to 30 years, increasingly, is more single persons being allocated social housing. And we're seeing a pinch point at that younger age group, sort of below 35, and also quite a lot of older people also being allocated social housing, increasingly due to a range of factors relating to financial and personal circumstances. So that swing towards single persons is quite different to what might have been the case historically.
Thank you.
Okay. How long were people waiting? I think these are quite good figures actually, because the perception is that people wait forever to get an allocation, and actually what we're seeing here is that if you're after a general needs property, 50% of people just over are waiting less than a year, and if you're wanting a supported housing property, 2/3 of people are waiting up to a year. So that's a pretty good turnaround. People might still like to wait a shorter period of time, but given the demand for social housing and the supply available, I think the timeframes there are quite good. And yes, some people are waiting more than 5 years, and we have to look at what we can do to reduce the number of people that are waiting more than 5 years. And the solutions to there are multiple and not necessarily straightforward. But I think it's positive how many people are getting an allocation within a year. Always we can work on improving that and reducing those timescales, but that's better than what people might imagine. Just some further final facts then about who's moving into social housing. We're seeing that 28% of new tenants are employed. We're seeing 88% of new tenants are being given a secure or long-term tenancy. We're seeing that 84% of new tenants are of a white ethnic origin. We're seeing that 20% of new tenants were previously homeless prior to being allocated their home. And we're seeing that 15% of new tenants were previously living in the private rented sector. So, and all of these pieces of information lead to more discussion and more thoughts, but this just to give you a brief snapshot of kind of who's being allocated what types of homes and how long people are waiting for, and the demographics of who's on our waiting list and who's being allocated. Final bits of context then. There's lots of actors involved in what happens around allocations. Ultimately, the UK Parliament for England sets the laws around the allocation and letting of social rented housing. It's a devolved matter in Wales and Scotland, and in Northern Ireland. So the governments for those countries set their own laws and their own policies around social housing allocations. But for England, it's the UK Parliament. The UK government directs policy for social housing allocations and decides what the priority should be. And this policy is then delivered by the Department for Levelling Up Housing and Communities, and they publish statutory guidance for local authorities, and they might publish other non-statutory guidance as well. For the Housing Ombudsman, they report to the Department for Levelling Up and Communities, and they're there to make sure that when people have got a complaint about the services they receive from housing associations, that those complaints are dealt with properly. And those complaints will cover a huge amount of housing association activity, but one of those things, of course, will be complaints about the allocation of social rented housing. It's important to note that local authorities have got a separate and different ombudsman where complaints about allocations from them will go to, and the housing ombudsman will only deal with complaints about allocations relating to housing associations. And then we've got the regulator, which works in tandem with the housing ombudsman and also reports to the Department for Levelling Up. The regulator of social housing ultimately will come in and determine how fit and proper housing associations practices are in relation to allocation of social housing, along with all kinds of aspects of its business. So lots and lots of different actors there that are having a different influence to varying levels as to what happens around the allocation of social housing for housing association policy and practice and what have you. We've got two national flagship policies, the sort of policy papers that have come out in recent times. The New Deal for Social Housing, which was a social housing green paper, and then the Charter for Social Housing Residents, which was the social housing white paper. These were attempting to set out more rights for social housing tenants, was the principle behind both of these papers. But tucked away in both of these papers was some content about the allocation of social housing, and it by no means was the majority of the content in either of these white papers and green papers, but they were important aspects of what was being talked about. The green paper, the New Deal for Social Housing, came out while Theresa May was the Prime Minister. The Charter for Social Housing Residents, the social housing white paper, came out while Boris Johnson was the Prime Minister. Now, of course, we've got Liz Truss, so hopefully we can move from the point of it being a green or a white paper into becoming a parliamentary bill and then ultimately legislation. But within those papers, within the green paper, that instigated an evidence collection from the Department of Levelling Up, talking to lots of local authorities and housing associations all across the country and others that were involved and interested in social housing allocations. And really the purpose of that evidence collection was to look at what was happening around the allocation of social housing at this current time, how well was that working, what could be done differently or better. So they've gone about and collected all that evidence over a period of time. They haven't published the results of their evidence-based collection, although the social housing green paper did commit to publishing those results, but to date those results haven't been published. Subsequently, the social housing white paper was published. This set out then some clear lines for where the government saw policy going forward, and this equates to both local authorities and housing associations. And the headline really is that the government wants to make sure that social housing is allocated fairly, which I think is something we can all get behind, that vision. There's particular nuances that the government's intending to pursue. The first of these is improving joint working between local authorities and housing associations. And of course, there is lots and lots of joint working between those two organisations, and continually looking at how we can make that better is not a bad thing. But the government's indicating that it will publish something in due course around what it would like to see around how local authorities and housing associations can improve their joint working around the allocation of social housing. The second of these then is that the government wants to see a removal of barriers to accessing social housing for homeless households. Now, we've already seen in the statistics previously that 20%, 1 in 5 allocations is made to a homeless household. The government understands from its evidence collection that there are some barriers there sometimes for some homeless households being allocated social housing, and it would like those barriers to be removed. And again, the government has indicated that it will publish something in due course around what it sees to be the barriers, and how it imagines those barriers might be removed. So it's something to think about and take and consider in advance of that paper coming out, and then obviously taking a look at that paper in due course as and when it's published. The third element then here, arising from the Social Housing White Paper, is the government wants to ensure vulnerable households are able to navigate local authority housing allocation systems. And whilst this is perhaps a local authority specific recommendation, housing associations are very often locked into those local authority allocation schemes, so it's of interest. And again, the government is indicating it will publish something in due course around what it imagines the difficulties for vulnerable households navigating allocation schemes at this current time, and how it imagines those difficulties being resolved. And then finally, the government's also indicated that it wants to see improved access to suitable homes for disabled people when social housing is being allocated. Again, the government is indicating that it's going to publish a paper on this as well. So we can expect quite a lot of activity and policy coming forward from the government around how social housing is allocated in due course. We should obviously try and get involved in any further dialogue the government wants around this, but also we can get on and do stuff about all of these things anyway, while we're waiting for this stuff to come out.
And Neil, just on that, when you talk about barriers to social housing facing homeless applicants, how do you think housing associations and local authorities can decide on how to prioritise homeless households, and what do you think needs to be in place for this?
Yeah, okay. So I did a big piece of work with Liverpool City Council and its housing association partners during last year. It had taken a different approach to allocating social housing to homeless households during the pandemic, because of the nature of the pandemic and wanting to make sure homeless people are off the streets. And there is no one single way, because each scheme is designed in its own fashion, so that each area is going to have its own way of prioritising homeless households. But there's some universal principles, and one of those key things is really good communication between the individual officer that's making the decision about allocations and the applicant who is homeless, the agencies that might be supporting that person during their homelessness, and the social landlord that might be then actually offering a property to that person. Having a really strong chain of communication and having all the parties together talking all the way through the process of someone registering, through the process of deciding what property to offer, through the process of viewing, and then tenancy startup. Really strong communication all the way through that is going to be really key. With the work we did for Liverpool, we looked at 20 different recommendations that could be done differently and better around how housing could be allocated to homeless households. I can look at sharing some of those more generally with people in due course. But Liverpool City Council are now working with me and their housing association partners to now implement all 20 of those. And some of that's around comms, some of that's around improvement to training, some of that's around improvement to IT platforms. So there's a mixture of things there that we could be looking to do. And of course, there's plenty of stuff people can take from the paper that you wrote, Becca, as well.
Thank you. And yeah, I'm sure members would appreciate sharing that information you mentioned about Liverpool as well. And just to say again, there will be an opportunity for other people to ask questions at the end of the session. So I'm sorry, I'm popping up every now and then. No,
it's good. It's good. Thank you very much. Okay, let's finish off some of this policy stuff. And here's some of the examples, in fact, that Becca was asking about. How can we improve how we allocate homes to homeless people and vulnerable households? More readily available information and assistance. So much more proactive, much more obvious, less passive. A lot of allocation systems are designed to be self-served, and actually vulnerable people and homeless people are not so readily able to self-serve. So we need to be much more proactive at providing that assistance and being aware that that assistance might be needed. Gathering more evidence of support needs at the application stage, better assessment of support needs at the decision stage, and making sure this remains updated throughout the whole time someone's waiting to be allocated a property. Involving other organisations that are supporting people who are homeless or who are vulnerable adults with viewings and follow-up visits. Again, a lot of the self-serve and self-reliance that many applicants are capable of isn't so true with people who are homeless or vulnerable, and they might miss appointments, they might not be able to attend appointments on their own, they might need different arrangements putting in place, and we need to be much more flexible about how we go about doing that. Identifying homeless and vulnerable households at the letting stage to ensure that appropriate support is available to them. And then carrying out appropriate risk and support assessments. Again, at the point that the letting starts, and all the way through then, so that it's a success, and working with partners, whether it be statutory or voluntary partners, to do that work. In terms of improving how we allocate homes to disabled applicants, and again, I'm doing another piece of work with Liverpool City Council and its housing association partners, looking just at this very thing right now. What can they do differently and better around allocating to disabled applicants? Certainly, again, we can improve the quality and relevance of information about property attributes and local neighbourhood facilities when we're talking to disabled applicants, and when we're providing them with information online or in a written format, or perhaps even over the phone or via video, making sure the information we're providing is relevant to them and their needs and their circumstances. We also could perhaps look at see if we can improve the information and the level of support offered to disabled applicants when applying for social housing. Again, many people can self-serve. Many people are able to go off and attend an appointment on their own without any help. Many disabled applicants are able to do all of that, but many aren't as well. And we need to be very aware, particularly because there's equality legislation issues here at play, that we need to be quite proactive at offering help and assistance, and being able to identify that, not waiting for disabled applicants to ask for any help or assistance or support. Everybody should consider using an accessible housing register. That's not me saying everybody should use one, but just you should consider it, and have an evidence-based policy that either says, yes, we are using one and this is why, or no, we're not using one and this is why. So if you haven't thought one way or the other about whether you should use an accessible housing register, now's the time to begin thinking about doing that very thing. Again, thinking about the format of housing options information, how is the format of your housing information option you've got at the moment, is it in the right format for disabled applicants? Have you spoken to disabled applicants recently and got their feedback on that information? And any feedback you receive, are you acting on that to improve it so it is in a format that's suitable for them? The effectiveness of your housing needs assessments, again, are they satisfactory taking up and accounting for the housing needs of disabled applicants? Are those assessments taking place in a way that's relevant and empowering for disabled applicants? And then marketing of new wheelchair accessible homes. How good are we about doing that? Are we making sure that that marketing is targeting the right applicants at the right time? So again, those are all things individually that you might be doing well or not so well on, but collectively, if we can improve all of them, it's going to make a big difference to disabled applicants.
We actually just have a quick poll for people on the call now, and it's not going to be shared wider than this meeting. It's all completely anonymous, but we just wondered how many of you actually have a register of accessible housing at the moment. And Suzanne will just put the question in the chat, and if you could just answer that for us, then we can just quickly see how common it is. I always quite like this bit and watching it change.
Yeah, all the answers popping up.
Yeah. Yeah, that's interesting. So the majority of people, it looks like the majority of people actually don't have one currently.
So there's lots of, there's some really good stuff on accessible housing registers. The Mayor of London published a really good practice guide, a really good practice guide on the Pan London Accessible Housing Register a few years back. That's a really good resource. The Equality and Human Rights Commission have also published advice on accessible housing registers and the difference they think they can make. And when the Equality and Human Rights Commission are suggesting something, given that they're a statutory body with powers to take action against people that aren't doing stuff correctly within equalities law, it's probably a good idea to pay attention to what the Equality and Human Rights Commission is saying. And in fact, their advice was jointly published by Habinteg Housing Association, which specialise in social housing for disabled people. So some good stuff out there that people look at and use to develop their own thinking on the use of accessible housing registers.
And just picking up on Sarah's comment in the chat, I don't know if you've seen it, but she says that they'd love to have one, but the local authority won't commit. Could you offer any advice in circumstances like that?
Again, I think that is about working with the local authority to build up an authoritative evidence base to say, here's the benefits to applicants, to the way our scheme works, to making best use of our properties for having an accessible housing register, and actually the costs of running it would be no greater than what's being done now, and there are some significant social benefits to doing it. So a partner being reluctant to do something with you is always a difficulty, and there is no magic wand that can make them get on board with it. But I think they may just not have the time to research it and understand the full benefits of it, and so it might be that you do the research for them to demonstrate the impact an accessible housing register can have, and why it's a jolly good thing to have potentially.
Great, thanks Neil, and thanks everyone for responding to the poll.
Okay, so context done, understanding of how the land lies, we've done that bit. Let's look at the legislation. There's actually more. This is all legislation for housing associations. There's other legislation for local authorities around social housing allocations. I'm not going to talk about any local authority allocations legislation today. It's just housing association legislation, and there's more here than what you might imagine. First of all, the Housing Act 1985, section 106. It says in relation to housing associations that housing associations must publish rules showing how applicants will be prioritised for an allocation of social housing. So if you haven't published those rules on your website, or don't make them available in other fashions and formats, then you're not complying with the law. So you've got to have some rules that explain how applicants will be prioritised, and you've got to publish them in a place where members of the public, whether they're thinking of applying or not, can view those rules. How you choose to prioritise applicants is up to you. You don't have to take account of the reasonable preference criteria that local authorities have to follow. You can prioritise applicants, providing it's not going to discriminate against anybody. You can prioritise them in any old fashion you want. But the principle here is you must have a set of rules that explains how applicants will be prioritised. You must also share the rules free of charge with any member of the public, regardless of whether or not they're going to apply. And you've got to promote the availability of the rules far and wide, so people can know that they're there. And you've also got to have, importantly, a full set of procedures that explain how you exactly will go about allocating social rented housing. And again, you've got to promote the availability of these procedures to current and future potential applicants. So that's a legal requirement on the part of housing associations. Have some rules that explain how applicants will be prioritised, have a full set of procedures explaining how every step of the way will be taken from the point of someone wanting to make an application all the way to then making that allocation at the end of the process and handing it over to the tenancy or neighbourhood team or whatever they're called, having a full set of procedures that explains every step that your staff will take. Not having the rules, not having the procedures, not publishing them, not promoting the availability of them to the public would be contrary to the legislation. It would be unlawful. So that's the first thing to think about there. The Housing Act 1996 provides a duty under section 170 on the part of housing associations to cooperate with reasonable requests from a local authority to offer accommodation to applicants with a priority for an allocation of social rented housing under the rules of the local authority scheme. So typically we make these come about in real terms through a nomination agreement and or through membership of a common housing allocation scheme. There are other ways you might do that, but principally the law expects you to offer accommodation when a local authority makes a reasonable request for it, and the mechanism for that is the rules of the local authority scheme, not the rules for your scheme. And the nomination agreement should set out how practically that's going to happen. And if you're a member of a common housing allocation scheme, you're effectively sharing one database, one policy, one website, etc. Then all of that's going to happen almost without you even knowing. If you're not a member of a common scheme with a local authority, then the nomination agreement is going to be much more important. Alongside that is the separate duty under section 213 of part 7, which is homelessness law, which is a duty to cooperate with local authorities for the use of housing stock to help the local authorities fulfil homelessness duties. So typically this will be to provide someone with temporary accommodation. So when local authorities are asking for a home from you, make them be clear about what duty they're wanting you to cooperate under. Are they making a request under section 170 to make an allocation for someone to potentially go into a permanent property, or are they making a request under section 213 for some temporary accommodation, which will be a different set of factors and circumstances in terms of someone's tenure and how they're given that property. So two duties, two different implications. Be clear that both those duties exist and how you're going about doing them, and be clear that if you're not doing them, again, because it's a legal duty, there's potential to be in breach of legislation.
Neil, just on that, in cases where the local authority and the housing association allocation policies conflict, which one takes precedence?
So the allocation should be taking place using the rules of the local authority scheme. Housing associations can have their own policies, and they should have their own policies. And if their own policy conflicts with the local authority scheme, let's say one policy says you have to have lived in the area for 5 years, and the housing association one is less generous than that, then there has to be something done to bridge the gap between those two policy positions. And the housing association can't refuse to be flexible. It has to show some flexibility in how it's going to apply its own policies and move its policy towards the local authority scheme. The local authority, ultimately the housing associations are independent organisations. They've got the right to make their own decisions, but they've got this duty to cooperate. And if the way their policy is written prohibits a housing association from cooperating with a local authority, then potentially they're in breach of that duty to cooperate, and then there's potentially legal implications for a housing association. So we should be trying to put our policies as near as we possibly can to local authority policies. More legislation then. Housing and Regeneration Act 2008, important piece of legislation because it defines what housing associations are and defines the remit of the regulator. So it's a good read if you're looking for something this weekend, but also it defines what social housing is. And actually, when you're writing an allocation policy, whether a local authority or a housing association, you should start here. This is the first thing you should read, and this should be the foundation of what shapes your policy. Because the law says social rented housing, whether it be affordable rent or social rent, and whether it be fixed term tenancy or long-term tenancy, social rented housing is low cost rental accommodation made available to rent below the market rate. That could be just below it or very much below it, to people whose needs are not adequately served by the commercial housing market. So people who can afford to buy a home on the commercial market because they earn enough or have enough savings shouldn't be being allocated social housing. The law is very clear about that. And the homes that, so people who are on the housing register should be people who couldn't afford to buy a home because they don't earn enough or they don't have enough saving, or potentially they might have enough earnings or savings, but their needs, their characteristics or their health or social care needs or their welfare circumstances prohibit them from being able to get a home within a commercial market. So we've got a really clear indicator of who should and shouldn't be being joining your housing register and who then should and should not be being allocated social housing. The Equality Act 2010 applies to housing associations when they're allocating social housing. So anyone who's applying to you for an allocation of social housing has the right to go to the Equality and Human Rights Commission if they believe a decision you've made about their application for social housing has resulted in unlawful discrimination. Often the Equality and Human Rights Commission will get all kinds of complaints from people about how their home's been allocated. Commonly is people were allocated a home without a garden, or they've been on the register for too long and they've simply not got a home at all yet. Applicants don't have the right to a home under equalities law, and applicants certainly don't have the right to a garden under equalities law, but they don't even have a right to join your housing register, but they do have a right to apply and for their application to be considered objectively, and any home they might be allocated has to be allocated again objectively using reliable and up-to-date evidence in a non-discriminatory fashion. And if any decision at any stage has been made as a result of intentional or unintentional discrimination, the Equality and Human Rights Commission can investigate and prosecute, and it can result in a penalty being awarded against the housing association by the courts. Housing associations can't exclude people from joining their housing allocation scheme because of any factor relating to the 8 protected characteristics that are set down in legislation. And housing associations must take steps to make, in relation to disabled applicants, to ensure that disabled applicants can complete application forms, they can attend offices or view properties satisfactorily within the parameters of their disability. So that means changes to common practice for people who haven't got disabilities. And housing associations must make sure people can get information about properties and how to bid for them. And that information, again, must be in a format and be provided in a fashion that's relevant to a person's disability. And of course, people can have either sensory or physical disabilities. So we've got to take all of those things into account. So there's quite a lot of stuff that the Equality and Human Rights Commission and the equality legislation expects of a housing association when it's allocating social housing. Immigration Act 2014 applies just to housing associations and private landlords, not to local authorities. It makes you carry out those right to rent checks. Failure to carry out a right to rent checks and results in a penalty being awarded to the council. So you'll have to go, to the housing association. The housing association will have to pay a penalty. And potentially, if the right to rent checks aren't done, someone can end up in prison for up to 5 years. And this can include a director or a manager or a secretary of a board. So it's of everybody's interest to make sure that you've got the right to rent checks, policies and procedures in place. You understand what this legislation requires of you, and you understand when you don't have to do right to rent checks as well, because there are certain circumstances where you don't have to do right to rent checks. There's probably a whole separate session on this at some other time. So be clear, you've got your house in order with right to rent checks. Data protection, again, when housing associations are allocating social housing, they're considered a public body for that purpose. And again, the data protection legislation applies. And if housing associations are in breach of data protection legislation when allocating social housing, then the Information Commission office can get involved. They can, again, levy a financial penalty against a housing association, and this can be millions of pounds potentially. So if an applicant believes that their information has not been protected properly, if they believe their information has been shared when they didn't give the permission to share it, then they can complain to the Information Commissioner's office. The Information Commissioner's office will undertake an investigation and decide whether the housing association has breached the legislation or not, and decide what penalty to levy against the housing association. So whenever you need to share information about an applicant to any organisation that's external to yours, including a local authority who you might have a nominations agreement with, let alone any other organisation, you've got to have overt explicit consent from an applicant. That's the big headline there. Case law. There's 3 really important pieces of case law if you're a housing association to understand. I'll run through them quickly. Weaver v London and Quadrant Housing Trust in 2008 made it clear, the courts made it clear, that decisions about the allocation of social housing are a public law function. So whilst for many functions that a housing association carries out, they're not a public body, when allocating social housing, they are a public body. And so all the things that are expected of a local authority in relation to allocating social housing, being objective, evidence-based, giving people an opportunity to provide the right evidence and what have you, all applies to housing associations. In McIntyre v Gentoo Group in 2010, the courts decided that the mutual exchange of social housing is also a public law housing function. And again, therefore, decisions have got to be objectively made and evidence-based. And again, then, most recently this year, TRX v Network Homes. Here, again, the courts decided that decisions made about management moves are also a public law housing function. And again, therefore, they've got to be objective and evidence-based decisions. So that means if, as a result of that case law, all your decisions have to be rational, have to be legal, and follow public law procedure requirements, whether it's a decision about allocations, mutual exchange, or management moves, they've got to be rational, legal, and follow public law procedure requirements. If any decision is irrational or illegal or has failed to follow public law procedure requirements, the courts can successfully overturn your decision and ask you to make a new decision. The Ombudsman may well get involved then, and the regulator may well get involved then, and that can lead to other penalties in other fashions. And we've already established that the Information Commissioner's Office expects you to share data properly, and they can put a penalty against you. And we've already established that the Equality and Human Rights Commission can also prosecute you if your decisions have been resulted in discrimination. So how do we protect ourselves from getting into trouble with the courts? We make sure that we rely on relevant information and disregard any irrelevant information, and we make sure that we have an accurate interpretation, an objective interpretation of all the relevant facts. We make sure that we understand the law. We know what law relates to social housing allocations, and particularly relates to housing associations allocating social housing. We understand that law, we've read it, and we've applied it to how we work. And when we're going to tell an applicant that they can't join our register, or they can't have that policy, or they can't have that number of bedrooms, or what have you, that we're giving them an opportunity to defend themselves before we make a final decision that's going to be adverse to their circumstances. And where the facts about someone's circumstances are uncertain and an applicant or any other relevant third party can't provide clarification about certain facts, then the applicant must be given the benefit of the doubt. The classic one here is someone asserts that they're a victim of domestic abuse. There's no evidence from any third parties about that domestic abuse. The courts will say, well, you have to give the applicant the benefit of the doubt of that assertion. Why would the applicant come into you and lie about being a victim of domestic abuse? So there's very clear legal thresholds that, again, all staff need to be aware of in relation to how allocations have to be and not have to be made by housing associations. So that's all the legislation done, quite a lot of it. Move on to the regulation. Here's our regulatory document, the Tenancy Standard. It was published in April 2012 when our regulator had some other different name. It's had so many names in the past 15 years. It's hard to keep up, isn't it? Anyway, despite this document being older than the current name of the regulator, it's still relevant. It's the Tenancy Standard. It's been there for 10 years now, so you should all be familiar with it. There are some required outcomes set out in this document. First of all, you've got to let homes in a fair, transparent and efficient way, which I think chimes very neatly with what the government's current policy position is and what the law expects of you. You've also got to take account of the housing needs and aspirations of current tenants and potential future tenants. So that is people that are going to apply and go on your housing register. So you've got to balance those things out, the housing needs of current tenants and future tenants, when deciding how the particulars of your policy, how you're going to prioritise people. Fundamentally, you need to take account of everyone's housing needs to make sure that your prioritising mechanism is appropriate. When making allocations and lettings, you've got to demonstrate to the regulator, should they ask for it at any time, that you are making best use of the housing stock you've got. So you're letting it quickly and you're letting it to those that are most in need of it. That the way you're allocating it is compatible for the purpose of the housing. So if it's for older people or extra care housing, that it's being used for that purpose and not for some other demographic or purpose. And when you're making allocations, you've got to demonstrate to the regulator that how you allocate homes contributes to the strategic housing functions that local authorities have to carry out, which again is complementary to the duty to cooperate. So the regulator is reinforcing that duty to cooperate in its own regulatory documents here. The regulator expects you to have a clear application, a clear decision-making process and a clear appeals process. So these should be straightforward and logical for applicants and for members of the public generally, as well as officers to follow. They should be readable, accessible, and ideally available for people to look at any time that they want to. And the regulator expects for all housing associations to provide an internet-based mutual exchange service, which I think everybody does. I can't imagine anybody not doing that. There's lots of stuff that can complement the regulations that go well above and beyond it. If you want to demonstrate how you're helping local authorities tackle homelessness, you can take up the National Housing Federation's commitment to refer. If you're not sure if your organisation's made a commitment to refer, then National Housing Federation have got a whole set of pages on its website around the commitment to refer, and including you can search by organisation who has made a commitment to refer. If your organisation doesn't appear in that list, then you can go away and do something about making that commitment to refer. You can get involved in the Domestic Abuse Housing Alliance and make sure that how you allocate social housing is compatible with the good practice standards that the Domestic Abuse Housing Alliance would promote. And of course, you can get involved with Homes for Kathy, which is a housing association-led initiative that, again, is looking to improve the reach and the potential impact housing associations can do around tackling homelessness. So there's lots of sort of stuff you can do to demonstrate to the regulator that we're meeting those regulatory standards and going above and beyond them. The regulator has some specific expectations of you as well. Again, it's reinforcing here the requirement for you to cooperate with local authorities. Again, it's reinforcing that you've got to assist local authorities in fulfilling its homelessness duties. Again, the regulator is insisting that you've got to meet the obligations that are set out in your nominations agreement, and you must adhere to them. The regulator is also saying that the way you allocate social housing has got to address under-occupation and overcrowding of your tenants. So that's something to think about in terms of how your scheme is framed. The regulator has also said that you must publish policies that explain how you've made use of common housing registers, common allocation policies, and local lettings policies. So the regulator is not saying you must be a member of a common register, or you must be a member of a common policy, or you must use a local lettings policy. But the regulator is saying you must explain how you're using those things, and if you're not using them, why you're not using them, and if you are using them, how you're using those things. If those policies aren't obvious in your organisation, then you need to go about putting those policies in place. And if those policies aren't obviously available for people to look at, then again, you need to go about providing a way that people can look at those policies and see how you're making use of those things. You've also got to set out and explain any criteria you might use for excluding actual and potential tenants, and that criteria has got to be non-discriminatory. Otherwise, you're going to fall foul of the Equality and Human Rights Commission. You've also got to make sure that how you allocate homes is user-friendly for actual and potential tenants. So you've got to make sure that you take account of people's support needs when you're allocating homes, which comes back to some of the stuff we talked about earlier on that's coming out from the Social Housing White Paper. You've got to make sure that when you're allocating social housing, you take account of people who do not speak English, or English is not their first language, or they have difficulties writing English, and you've got to have alternative ways of working with those people in the way you allocate social housing to take account of all of that. The regulator also expects you to minimise the time properties are being empty, which I think is something every organisation aspires to, but not at the account of people that have got particular needs. So you've got to take account of the circumstances of each person when they're being offered a property. And if you have a standard, you've got to reply and have confirmed whether you want to accept or reject this offer within 24 hours. You can't do that for every applicant. For some applicants, they're legitimately not able to respond within 24 hours or whatever your time frame might be to decide whether they should or shouldn't accept or reject a property. You've got to have some appropriate deviation and context for tenants who can't respond in your standard times. You've got to record all of your allocations activity on the core system, which I think most people do. And you've got to provide tenants who are wishing to move with advice about their housing options, which is something I think probably many housing associations could improve on, actually. That housing advice option stuff is really important. There's a whole bunch of stuff around mutual exchange, right? I think most housing associations are satisfying the internet-based service. People are able to, and it should be free to tenants. They should be able to register, enter their current property details, be provided with properties that match them. We've got to make sure that people who can't use the service themselves are getting help to use the mutual exchange service. And you've got to make the availability of that help obviously notify people that help is available and make it very obvious that help is available. Administration, there's lots, I'm very conscious of the time, Becca. There's lots of guidance out there for local authorities, very little guidance for housing associations. There's 2 documents. They're really old. They both came out in 2004. You can see that the National Housing Federation logo is on the bottom of one of them. And the Housing Corporation is on the other one, is on there as well, so you can see how old the documents are, because it's been several different names since then. But they're still current, and they've not been replaced, and they're still really important for you to read. The first one, Allocations, Homelessness and Stock Transfer, A Guide to the Key Issues, is really important if you are a stock transfer housing association. The other document, Effective Cooperation in Tackling Homelessness, Nominations and Exclusions, is really important for any housing association. All housing associations would benefit from reading and following that advice. It's still relevant, up-to-date advice. Quickly on on contracting out, which is what the first guidance talks about. Contracting out is a commercial decision. It's not a legal requirement for you to deliver a local authority's housing allocation scheme. It's a commercial decision you'll make. You don't have to run a local authority housing allocation scheme if you don't want to. Even when you do decide to run a local authority's housing allocation scheme, you've got to make sure that you're clear within the terms of your contract what penalties might be levelled against you for decisions that are unlawful or general contract failure. Complaints about how you run a local authority's housing allocation scheme will go to the local government ombudsman, because it's the local authority scheme. Even if you're doing it for them, the local government ombudsman will look into it. Any contract you've got with a local authority, and you should have a contract with a local authority, any contract you've got to run a local authority's housing allocation scheme cannot in law be any longer than 10 years. So again, go away and check your contracts, check you've got one, check the length of it. If your contract does exceed 10 years, have a chat to your local authority and talk and see about what you can do to remedy that. The Secretary of State insists that, so the Minister for the department insists that there must be a clause in every contract between a housing association and a local authority for them to carry out allocation functions, that the Secretary of State is able to terminate the contract, but only within reasonable parameters of that termination could be made.
And just on this, Neil, how far can housing associations get involved in decisions on allocations, given the statutory duty rests with local authorities?
Great question. So housing associations can get involved in almost everything around deciding of an allocation. The primary thing a housing association can't do, the primary thing a local authority can't contract out, is the actual overall policy. The local authority must write and publish the policy itself, although they could appoint a reliable consultant to work with them to write that policy, but they can't contract out the writing of the policy to a housing association. If the local authority have got to write it, they've got to put it through their full council and approve it through their democratic process. But all other aspects really of allocations work can be contracted out to a housing association. But if a housing association made a decision that was unlawful, the local authority would receive the penalty for it. But the local authority might pass that penalty on to the housing association, depending on the terms of the contract between the housing association and the local authority. Does that make sense?
Yes, that does. Thank you.
Okay. Nominations agreements, some stuff around nominations here. Typically, nominations agreements provide for 50% or more of true voids for a nomination. Periodically, you might want to review what that percentage rate is and whether the established rate you've got is still relevant and applicable for you as a housing association and the local authority you might hold that agreement with. The nomination agreement is there to help make sure that all types of applicants get nominated to a property you have available to let, not just some, so it should be covering the whole gamut of people on the housing register. There should be monitoring between the local authority and the housing association, regular monitoring of the number of successful and failed nominations and monitoring the reasons why. There should be regular void reports, and both parties involved in the nomination agreement should be getting together regularly throughout the year. The more nominations you make, the more often you're going to want to get together to look at how well all of that nominations process is working and how many tweaks we might make, and to continuously look to improving that nominations approach. There should be a joint approach to developing any exclusion criteria. Blanket bans are not allowed. You cannot say this person is banned from applying for our housing. That's just not legally permissible. You might exclude them from until certain circumstances change for an individual applicant, but you can't permanently ban someone, and you can't ban a whole group of people by experience or characteristic. Nominations have to be made in accordance with the local authority's housing allocation scheme. They can be determined in accordance with your allocation policy, but as we said earlier on, if your policy conflicts with the local authority scheme, then you're at risk of failing in your duty to cooperate, and so you might have to move some aspects of your policy, amend some aspects of your policy to be closer to what the local authority scheme is. There's got to be a recourse for dispute resolution within the nominations agreement, and there should be opportunities for operational staff to resolve a dispute, and then senior managers within both organisations to resolve a dispute. And if the dispute can't be resolved, then you appoint a third party, such as a barrister or some other housing law expert, to help you resolve the dispute before anyone goes down the route of courts or regulator or anything like that. The nominations agreement should set out what support people are going to get to sustain their tenancies. And the nominations agreement should set out clearly the information that you're going to provide, and also the information that the local authority is going to provide. So lots that should be there in nominations agreements.
And Neil, sorry, just going back to that, and Sarah, I can see you've got your hand up, so I'll pass over to you in a minute. And also, I am aware of time, so we'll probably extend to about 12:05 and then have a bit of a break and then come back to Mary. But I just wondered, in terms of nomination agreements, what provision should be made for dispute resolution? And also linked to that, we actually have another poll for you. Okay. Again, which is anonymous, but asking whether you regularly review nomination refusals with local authorities. But if Neil, if you could talk about provision for dispute resolution, that would be great. Yeah,
okay, that's fine. So the guidance that I mentioned earlier on, let's just go back to the front cover of it. This guidance on the right-hand side of the screen, effective cooperation in tackling homelessness, nominations, agreements and exclusions. This guidance is really good, and I recommend everybody reading it. And if you want a copy of it, then get in touch, and you can find it on a Google search, but I've got a copy of it. But the guidance here, which is really importantly, comes from the government, comes from the regulator, comes from the national membership body, the NatFed, comes from the local authority membership body. So it's been written by everybody in collaboration, and this guidance makes it really clear there should be a dispute resolution clause in the nomination agreement, first of all. Secondly, it says that the dispute should be at the first instance resolved by operational staff. If it's still not possible, it should be escalated to directors. If it's still not possible, then it should be escalated to an independent third party that both the housing association and the local authority jointly pay for them to look at the matter, and the decision of that person should be accepted by both the housing association and the local authority. And if still a resolution can't be made, if there's still a dispute, whether it be about a nomination case or the way the nomination agreement has been drafted, or whether the nomination agreement is being implemented, whatever the dispute might be about, if there's still, after all those steps, still a disagreement, then you might contact the regulator, or a local authority might go to the courts and say this housing association is failing in its duty to cooperate. Nobody wants to get to the point where a local authority goes to the courts to say this housing association is failing its duty to cooperate. Nobody wants to get the regulator involved to say, can you check whether they're satisfying the regulatory requirements, which is why all of that stuff is in there around dispute resolution. So all that is really important to have that clearly set out in your nomination agreement.
Thank you.
So my question very quickly was just...
Oh, sorry, could I just... sorry, Sarah, I'll go over to you in a minute. I was just going to say, on it's interesting, the poll results as well. So 46% of people had review refusals with some local authorities, 39% don't at all, and then 14% with all local authorities. We looked at that as part of our housing homeless families research, and did make a recommendation that housing associations should do that, just as part of reviewing your process and improving your process. And I'll pass to Sarah, and then we've got a question from Nick, but we have got time at the end for more questions. But Sarah, if you could ask.
Yeah, just real quickly, can you remind me of the definition of a true void versus a void?
Now you're asking, not off the top of my head, but it's set out in that nominations guidance that I've talked about. That's a good place to get that from. It's an important definition, and it should appear in your agreement. And I've written hundreds of nominations agreements, but it won't come to my mind off the top of my head. But there's a good definition in that guidance that you can rely on.
Should we take a couple of questions from the chat and then just save the rest for the end? Okay, yeah. Just so Nick's asked, does it matter if the local authority does not take up their nomination rights?
Well, in some ways, no. You know, if it's choosing not to take up its nominations rights, then so be it. I suppose as a housing association, you might want to get in touch with them and say, you have 50% noms, you're only using 30% of our voids. Why aren't you using the full 50%? You know, because if they don't need them, you might want to renegotiate the terms of your nomination agreement and negotiate a lower nomination rate. Equally, it could be that they do need them and they're just not very good at exercising their nomination rights, or they didn't realise they had a 50% rate or whatever rate you might have. So I think it's worth having a conversation with the local authority, and it's a bit like the monitoring of failed and unsuccessful nominations, where they're failing. If a local authority is not coming back to you and wanting to do that monitoring, often it's because they simply don't have enough staff, to be honest with you, particularly in stock transfer councils, where people almost forget that there's still some housing functions left, particularly allocations. Lots of stock transfer councils, there's a belief that there's nothing to do with allocations because we transferred that all down the road to the housing association, and that's simply not true. So often local authorities aren't making best use of their nominations or meeting with you regularly to see how effective the nomination process is working, because they simply haven't got the staff capacity to do that and don't realise they should be doing that. So that might be you doing a bit of hand holding and lead them along the way to make that relationship work as well as you possibly can do.
Yeah, and we've got a question from Amy about our sheltered housing has capital limits for applications. Does this mean that the local authority limits take precedence if higher?
It depends on the terms of what was put in place when your sheltered housing was developed, and this happens often a lot again with new build schemes, where there's a nomination rate fixed on the first letting and then the rate changes on subsequent lettings. Nomination rates might be again different for extra care housing scheme on both first and subsequent lettings compared to the general nomination rate. So you know, the idea that there's simply one rate and one agreement actually is a bit misleading, because actually you'll end up potentially with variations of your typical nomination arrangement. And so again, the benefit of meeting with the local authority regularly is keeping a grip of all of those small variations for different schemes and making sure that again those variations remain relevant. So in terms of your particular housing there, you'd need to look at what were the particulars when it was first developed, and what were the subsequent promises made after the initial let.
Thank you. And I'll just let you go through the last of the slides and we'll pick up questions, including ones I've got later.
Super. Suitability of offer. This is a big matter around administration. When you offer someone a property, they should neither be overcrowded nor under occupying. That's the advice from the regulator, really. You can, however, on the under occupying factor, have some degree of flexibility if you want to choose to do so, but you should be demonstrating that if someone is under occupying a property, they can still afford to pay the housing cost at the time that the allocation was made. But the regulator is expecting properties to be put to the best possible use, and allocating a property that results in someone under occupying it arguably isn't putting it to the best possible use, although say there may be causes every now and then to go against that. The overcrowding thing is much more straightforward. You simply legally as well as regulatorily can't allocate a home where someone is overcrowded, and you need to know what the legal parameters are of overcrowding law and make sure that staff understand that when a property is being offered. Affordability, there's probably a whole separate chat around affordability. There's a huge amount of evidence available as to what you can and can't do around checking that a property is affordable. There's legislation that you need to take account of, case law that dictates what should be included within someone's income and not included. So we can come back to that in due course. Location, you've got to make sure that the location of the property being offered allows the applicant and any of their household members to make essential journeys, to get to school, to get to work, to get to essential healthcare appointments. The journey doesn't need to be as easy as where they were previously living. It doesn't need to be their preferred or most desirable journey, but they do have to be able to make the journeys they need to make and get to and from the places they need to get to at the relevant times of day that they need to get to and from them. And if you're allocating them a property that then means someone can't get to work or can't get to school on time or back from school or work, then that's not going to be a suitable offer. When making an offer, you've got to take account of the protected characteristics of an applicant and make sure that you've considered that fully when making the offer. when making an offer of accommodation, you've got to think about the safety and welfare of children and make sure that the accommodation you're offering is not going to compromise the safety or welfare of any children that are going to live with the applicant. You've got to make sure that the accommodation you're offering allows children to continue to attend school. It doesn't have to be the same school, although it's more important for them to attend the same school where they're taking examinations or where they've got a special educational need. So you want to give some consideration to those things. When making an offer, you've also got to take account of the space, the arrangement of the property and the standard of the property to be confident that it's suitable. And you've also got to take account of the health and welfare needs of the applicant. A property has to be suitable, not desirable. This is not dream home territory. There's no requirement for it to be their preferred property, their most desirable property. It doesn't have to have south-facing view. It doesn't need to be near a transport interchange in a Waitrose, although if it happens to be, that's all great. It simply has to be suitable. What you have to prove to the applicant, and any challenge you get from the courts, the regulator, or anyone else, is that it was a suitable offer, and how you demonstrate suitability should be clearly set out in your own policies. Affordability, which we touched on the previous page, there's so much stuff here to take account of. There is legislation from the Supreme Court, which is the highest court in the land, that talks about what we can and cannot take account of in relation to affordability. So when looking at whether doing affordability checks at the point that an offer is being made, or any other part of the process of making an allocation, we should be looking at what can an applicant afford, taking account of their total income, which includes their earnings and any welfare benefits they might be in receipt of. And earnings can extend to all kinds of things. You need to have a very clear definition of earnings, and it can be quite extensive. You need to allow an applicant reasonable living expenses equal to the DWP standard allowances for items such as food, clothing, heating, transport, and other essential items. You also need to allow an applicant reasonable expenses for nurturing and safeguarding any children who are either emotionally or financially dependent on them. Important point, the children don't have to live with the applicant. There just has to be evidence that children are emotionally and financially dependent on an applicant. And if they are, you need to allow them reasonable expenses for that. You also need to take account of an applicant's priority debts, but you can ignore their non-priority debts. You need to balance all of the above against the housing costs and see whether an applicant can afford them. And if your affordability calculator doesn't follow that route, you're not according with the Supreme Court, and you're going to be in breach of law, and that's going to cause problems for you. So again, if you want to talk further about affordability with me in due course, come back to me, because there's lots you can talk about around that one. Other matters, when deciding a number of bedrooms that people are entitled to, are you going to use the government's bedroom standard for overcrowding legislation? Are you going to use the DWP's criteria for bedroom entitlement in relation to welfare benefits? Or are you going to use some other criteria of rules for how many bedrooms a household can have? Whatever set of rules you follow, they've got to be very clear within your policy. If you're using a local letting scheme, there's 5 key steps you should follow there for when you're producing your local letting schemes. There has to be evidence that the scheme is needed. The scheme can't be indefinite, or if it is going to go on for some significant period of time, then there should be reviews and evidence for its need should be updated. And when there's no evidence that the scheme is needed anymore, the scheme should come to an end. Discretion, you can only apply discretion to an allocation in limited circumstances and in line with what your policy says. And if you apply a discretionary decision to one applicant in one set of circumstances, you automatically must apply it to all other applicants in the same circumstance. You can't wait for an applicant to ask for discretion. If you offer discretion to one applicant with one set of characteristics or experiences or one set of needs or circumstances, you must automatically apply to everyone. So you need to think really carefully before you award any discretionary decisions. Finally, there's a link to tenancy policy here. Allocations have a very strong link to tenancy policy, and tenancy policy is covered in the same regulatory standard. It's a regulatory requirement for housing associations to have a tenancy policy. You've got to update your tenancy policy whenever the local authority updates its tenancy strategy, and more often if you wish to do so. And your policy's got to set out clearly the types of tenancies you're going to offer, how you're going to undertake your tenancy management, what you're going to do to help people sustain tenancies, what you're going to do to prevent evictions, and what you're going to do to tackle tenancy fraud. All of that should be set out in your tenancy policy. If all of that's not covered in your tenancy policy isn't going to stand up to scrutiny and isn't doing the job that the regulator expects it to do. There you go. I'm sorry for overrunning so much.
No, only by 10 minutes, and I think it was worth it because that was incredibly informative and just full of really helpful insight, and also just all the important legislation and guidance and information that we need. So we're going to have a short comfort break now, and I think I'll just make it about 3 minutes. I hope that's enough to make a cup of tea or whatever else you want to do. So if you could come back by 12:13, then we'll hear from Mary for 10 minutes about what they've been doing in Greater Manchester Combined Authority. Thank you.
Thank you.
Hi everyone, welcome back. Just going to pass over to Mary now. Thank you, Mary, for joining us. So as I said at the beginning, Mary is responsible for the housing strategy at Greater Manchester Combined Authority and working with various partners. But Mary's got a presentation for us for 10 minutes, and then there's the opportunity for discussion at the end. Thanks.
Thanks, Becca. I'll just get my slides up now. So I've got some slides that give a bit of a brief overview of Greater Manchester and what we do, and but I'll sort of fly through those, and the slides will be shared afterwards so you can look at the detail, and then talk a little bit about the Greater Manchester Allocations Network that has recently been set up this year. So I'll get on with it, I guess. So just very brief overview of Greater Manchester. Those of you some of you on the call may be familiar with the area, some may not. So it's a conurbation in northwest England, made up of 10 local authorities, with including Manchester being the largest local authority there. It gives you a sense of the population spread there. It's about 2.8 million people living in Greater Manchester at the moment. And just a little bit about our housing market. So there's 2.8 million people live in approximately 1.2 million homes, and the population is forecast to grow by around 250,000 people, with an extra 200,000 homes needed by 2035. Some of the initial census results from the 2021 census have shown that Greater Manchester had above average population growth, Manchester specifically driving a lot of that population growth over the past 10 years. The last sort of 10-year census period, 2001 to 2011, we saw a lot of growth in the private rented sector, and we're expecting to see another growth in that, but that data hasn't been released to us yet, but that's what we're expecting to see. And some of the situation that Neil was discussing, obviously a lot of it applies to Greater Manchester as well. We have had over 92,000 social homes sold through Right to Buy since 1980 in Greater Manchester. And also looking at the data that Neil ran through at the start of his presentation that was really useful. The housing registers data shows that we have got 30,000 households on housing registers in Greater Manchester in a reasonable preference category, and around 45,000 not in reasonable preference. So to be clear, that's on the 10 local authority housing registers. Greater Manchester doesn't hold a housing register. We're not a stock holding or stock owning authority. We don't allocate housing. We're not subject to that part of the Housing Act. But the local authorities within Greater Manchester, all 10 of them have their own allocations policies and housing registers that they keep. We have seen an increase in rough sleeping to up to 2018, but we have also seen a really good reduction in that in the years since through a range of local interventions and partnerships as well. We also have some affordability issues, which again, we're expecting to see worsen over the next few months. But with around 30% of households would have to spend more than 35% of their household income to meet median private rents. And we also have a retrofitting target of around 61,000 homes each year that need to be retrofitted. Obviously, that's a huge job, and that includes a lot of social housing as well. Obviously, there are initiatives such as the Social Housing Decarbonisation Fund to support that, but clearly it's not hitting that level, that number of homes every year. So that's a big challenge. And also, we know that we've got a need for supported accommodation for older people as well. Around 15,000 more units of that will be needed by 2035. And then I just wanted to sort of run through Greater Manchester Partnership working and what Greater Manchester Combined Authority is, I guess. So very briefly, all the 10 local authorities have been working together for a long time in sort of a voluntary sense since 1986. But then that put Greater Manchester in a really good place to be ready for devolution deals. So we've had 4 devolution deals in Greater Manchester, the first of which was signed in 2009. Health and social care devolution followed in 2015, so we are responsible for the NHS and social care services and spending in Greater Manchester. And then we also had the agreement for a mayoral combined authority, with the mayor being elected in 2017, so that's Andy Burnham. So that's Greater Manchester Combined Authority was formed just prior to the election of the mayor to deliver on the mayoral manifesto commitments and priorities. In terms of working with housing providers, the 24, I think, currently biggest housing providers in Greater Manchester have established a Greater Manchester Housing Provider Partnership. So they work together across a range of strategic and operational issues, and can kind of speak as a uniform voice for the sector in Greater Manchester. And we, as GMCA, signed our first memorandum of understanding with them in 2016. Which was about how we would work together as organisations to further our goals, and that has led to joint working across a range of strategic priorities. So A Bed Every Night is a GMCA homelessness initiative, which has helped on that reduction of rough sleeping. But it's been delivered jointly by local authorities, the housing providers, and the NHS as well. And this followed last year a tripartite agreement, we like to call it, between ourselves, the housing providers, and the NHS in Greater Manchester, just solidifying our commitment to work together on the Greater Manchester housing strategy, which I will read on to now. So I should say Becca's introduction was very kind. I'm not the only person responsible for the delivery of the Greater Manchester housing strategy. There's a small team of us at GMCA, but also it is a Greater Manchester housing strategy. So it's not just a GMCA strategy. We can't deliver this on our own. It's all about working in partnership with different organisations. But the strategy was published in June 2019, and the priority we have at a Greater Manchester level is the priority for safe, decent and affordable homes for all residents. This isn't a statutory document, but it's about where a Greater Manchester approach adds value to local activity. And it was very much co-produced strategy. It was in wide consultation with local authorities, housing providers, the sector, so developers and architects, housing activists, local residents. Many more people were involved in this. And we had 20 themed writing groups and a district listening event in every local authority as well. The key underpinning that is the connection between housing, people and place. And I just mention this because I want to put the work I'm going to be talking about around allocations into context, in that this strategy is very wide ranging, and it takes in, so we have our sort of A priorities and our B priorities. That's not ranked in terms of which are more important. That's just the way that they've been sort of labelled. But essentially the A priorities are around the current housing stock that we have and making sure that everybody is able to access that and it's appropriate. And so there we have homelessness and rough sleeping, work around the private rented sector, services to support vulnerable households, those who may need adaptive properties. And then we have improving access to social housing for those who need it, which is where this work that I'm going to be talking about sits under. And we also have work around retrofit. And then the other section of the strategy looks at new homes. So very important in the context of access to social housing to say that we understand that the biggest probably issue facing the sector is the lack of supply. So that there is work ongoing in that, in terms of new models of housing delivery, investing in truly affordable housing and ensuring that there are choices in the market for GM households, particularly those with the different needs. And just to say, we also have strategic enablers underpinning the strategy, which includes the tripartite agreement and agreements with Homes England. But again, working together is the only way we can deliver this. So just want to put the access to housing work stream in context. So that graphic there, I know it's quite difficult to see, but that is a graphic of the housing registers as I described earlier. So it shows that across our 10 local authority areas, we've got quite different setups. So the red there is households in reasonable preference, and the grey are households not in reasonable preference. And it shows the differing setup. So in some local authorities, only households with reasonable preference are able to join the register, for example. In others, it's not the case. And, there's a real kind of mixed kind of delivery there across all of those 10 local authorities. They all have different policies in relation to their own local needs. But we, putting this work in context, we know supply has been reducing, as Neil outlined very effectively in his presentation, and new supply isn't going to come through quickly enough to alleviate the high demand we're facing at the moment. And just the wording from our housing strategy around this work is that we want to be looking at building and managing allocations processes to deal fairly with a complex mix of people with varied needs. It's a huge challenge. We want to explore the benefits of coordinated Greater Manchester housing allocations framework. It's one way to improve the accessibility and availability of social housing. To be clear, we're not going to be implementing a Greater Manchester housing allocations policy. That wouldn't be appropriate because we don't have the duty to provide social housing, and also because local areas have their own needs and different priorities as well. But it's about looking at where can Greater Manchester working together add value and really support some of those who may be struggling at the moment with accessing social housing. So in terms of this work, we've been working in partnership since, I've said 2016 there, but it's probably longer than that really. But some milestones we've had in 2018, we undertook quite a large research project as the GMCA, where we did an analysis of allocations policies and produced a big matrix that talked about all the various different aspects of those policies and compared across the 10. Had kind of quite structured interviews with colleagues that are allocating housing across the 10 local authorities. They were both people working in local authorities, but also in housing providers, where housing providers are managing the registers. In 2020, there was a joint steering group set up of local authority, GM housing provider and GMCA officers, and they were looking at the reality of allocations processes and pressures on the social housing system in GM. And through this, we had some themes to explore which came out, which were around the outcomes of allocations policies and processes and whether they're always intended or not. Also something around a two-track approach to allocations. So as we've discussed today, the prioritisation of housing homeless families can mean that there is some, exceptional kind of some direct lets that are maybe outside of choice-based letting systems and other kind of initiatives that are happening whereby lets are sort of being done by different means than the usual CBL. We also wanted to look at how CBL systems are and aren't working. So 9 of our 10 local authorities use choice-based lettings, and also kind of restrictive policies. And we talked about this earlier as well, where people are, are not nominated to a property, or why that might be, and how we can work to enable sustainability for housing providers, but also to allow our residents the best chance of being allocated housing where needed. And what came through this was that a gap was identified. So in Greater Manchester, we have quite a lot of groups that operate at Greater Manchester level, where we have local authority and housing provider reps come along and discuss issues. So we have a strategic housing group, we have a homelessness group, but there wasn't really any group of people coming together to talk about the allocation system, share best practice and work towards joint solutions. And that is where the GM Allocations Network was born, essentially. So the purpose of the network is to consider, coordinate and progress GMCA, GM districts and GM housing providers' work on access to social housing. And we've got an allocations network work plan. So I've put, obviously you can't really read that there, but just to give you an idea, we've got kind of various themes that we work on, and we have a bit of a where we are now, where we'd like to be, and what activity do we need to get there, is the approach we've taken to kind of building that work plan. And the role of the network is to bring together expertise and allocations, discuss issues and share best practice in order to make positive change in allocations processes in GM. If there are sort of local issues that need to come to a GM forum or to be addressed more formally at a Greater Manchester level, we can provide that forum, share best practice, remove barriers, delivery of activities and outcomes of the allocations network, dissemination to other groups that people may be attending, and looking at informing and shaping strategy and policy development and implementation of housing access and allocations policy as well. I don't mean that in the sense of allocations policies, but policy around this area. So the allocations network has been meeting since February. So we meet monthly pretty much at the moment, although getting time in diaries can be tricky. And it's an hour-long meeting, and we have a bit of a best practice sharing session. Then we do kind of any local issues that have come up, any updates we have to the work plan, and any other business. And that's kind of the format of the meeting. We've had some external presentations. So Becca has joined us to discuss the research that the National Housing Federation recently completed on housing homeless families. We've had local members of the network have brought their own work that they're doing locally around, for example, working with planning and new supply and utilising allocations data to influence that. So what works well with the group is that it is an opportunity for the discussion of tricky issues in kind of a quote unquote safe space. That's between both housing providers and local authorities, to be able to discuss kind of both policy but also quite practical operational issues and get that different take on it. Sharing best practice has worked really, really well, and we've had really positive feedback on that, and people taking things away and starting different conversations. And I think hearing perspectives from different organisations is useful, because even though housing providers will typically be working closely with local authorities on allocating social housing, sometimes there's not that space to have the conversation about how things work for each organisation. So this tends to be a really useful network for that. But I wouldn't want to say that it's without its challenges as a network. It's difficult when you're bringing together people in different roles to find that all the topics and subjects that you want to cover are going to be relevant to everyone, and everyone is going to feel that they have something to contribute. Naturally, finding kind of the right mix of topics to bring is some ways tricky. Fitting in, so in terms of the work plan, we do have a sort of bit of a structure around what some of those themes might be that we want to talk about, and nominations has come through as something that we'd like to discuss in terms of there are very different nominations agreements in place in different areas, and is there something that can be learned from around review of those and working together to make those work best for everybody. Looking at local lettings plans, qualification criteria, tenancy sustainment. So those are some of the themes that have come through. But again, obviously, not everybody will be looking at all of those in their day jobs. So that's something to think about. Obviously, fitting in any extra activity around a job that is extremely busy and difficult is always hard. So we try to be as supportive as we can, but kind of getting that momentum to get those projects off the ground can be a bit tricky, and people are rightly wary of taking kind of ownership of a big piece of work when they've got their own organisational priorities to be working to as well. But that's not to say we don't have ambition. So the network is continuing to meet monthly. We're probably going to review whether that still needs to be the case, or whether we might want to go to maybe a slightly longer but less frequent meeting, and maybe start having some ideas of steering groups of different bits of work to take forward. But our ambition is supporting our homelessness prevention activity by making these positive change to allocations processes and policies through the longer term, working towards a GM allocations framework rather than not a shared allocations policy, obviously, but having almost a framework of whereby we can say, when you're reviewing your allocations policies, have you thought about looking at this issue or this group of people, working slightly differently with these individuals or this type of stock, those sorts of things. So that's what we're working towards. So yeah, I'm happy to take any questions or comments. If I can answer them, I may not be able to, but yeah, thank you very much for having me.
Thank you, Mary. It's really inspiring to hear about the work that you're doing there and the great partnership working that's happening. We've got about half an hour now for questions. I mean, I have one to kick us off, but feel free to put your hand up or pop them in the chat, and we'll keep track of them. I just wanted to follow up with Neil on his presentation. And just talk about the suitability of offers. So one of the issues around suitability of offers for homeless applicants is that they made fewer offers than those on the general housing waiting list. So, you know, if you come through from Part 7, you have fewer offers in Part 6. So that can create issues in terms of sustainment of tenancies. And have you seen good practice here on how housing associations can work with local authorities on ensuring offers are suitable?
It's such a good question. It's such a big issue of conversation, big topic of conversation. And this is a little bit in deluxe sites, in the Department for Levelling Up sites, because they're quite aware that as you said, people who are, particularly those that owe a homelessness duty, are often given less rights of choice, whether it be particularly or less rights to refusal, compared to other applicants. And there's a point of efficacy here. Is this fair? Is this why should, just because their circumstances dictate that they should get less offers? If we said disabled applicants or people with mental health needs had less offers compared to everyone else, would that be fair as well? So there is something on the government's radar about this, and in due course they may well issue some opinion or perspective on it or practice on it. So keep an eye out for that and just bear that in mind when you're doing your local stuff. I think I understand from a local authority's point of view, they've got people in temporary accommodation and they want to move those people out of temporary accommodation. And one of the ways of doing that is making them an offer of social rented housing. And obviously, the more choice someone's got, typically the longer more choice of social housing allocation they've got, the longer they might remain in temporary accommodation. And local authorities have got a pressure to move people out. Temporary accommodation is very costly. Lots of local authorities, if they don't have their procurement arrangements sorted out properly or their allocation of TA arrangements sorted out properly, they end up using B&B or other forms of less appropriate TA, temporary accommodation. That builds up costs, it builds up all kinds of pressures and dissatisfactions in other ways. So I see it from a local authority point of view that they have got a preference to minimise the amount of offers made to applicants who are owed a homelessness duty because it helps them with other statutory functions. I see it from the applicant's point of view that actually they're giving less right to choice than others, and that's unfair. There is a middle ground somewhere, I think, to be made here. And again, key amongst all of this is making sure that coming back to the term suitable, an applicant should be reminded, whether they're homeless or not, that they're only ever going to be given an offer that is suitable, never desirable. We don't work in the world of ideal homes, unfortunately, and so we should try and give parity to all applicants in terms of the number of bids they can make, and the number, if bidding is part of the way you allocate, and the number of offers of refusal that they should make. The offers at homeless applicants should have parity with other types of applicants. But the overall conversation, whether applicants have only one right to refusal or many, the conversation should be concentrated on, again, all social housing guarantees is a guarantee of suitable offer, not a preferable offer, if that makes sense.
Yeah, that's great. Thank you. Mary, have you got anything to add from GMCA perspective? Do you want me to run? I can remind you of the question.
Yeah, if you could. I mean, just to say that Neil's completely right that there's obviously going to be pressure from the local authority, and they want to be, moving people on from temporary accommodation as much as they can, and this is something that comes up through discussions we have around, we wish we could give more choice to everybody. I think, I don't think anyone on this call doesn't want to be in the position to be able to offer homeless households choice in where they can live and what kind of accommodation they can live in. But the reality is that the stock pressures are such that it is, as Neil said, you're not always going to be somewhere that would be ideal for you. So does that cover it, or have I missed a bit of the question? I'm sorry because I may have missed a bit.
Oh, no, I think that covers it. And actually, Charlotte, I can see your question in the chat, and I will ask this, being a bit selfish and hogging the questions, but just linked to the suitability of officing. Something that we see from the research that we do is around one of the main areas that local authority and housing association policies conflict is around bedroom standards, and kind of because there is such a pressure on stock there, and so I just wondered for either of your thoughts on that, and how that those kind of conflicts affect suitability of offers and the kind of bedroom standard issue. I know you touched on this, Neil, in your presentation, but whether there's anything more you can say.
Yeah, I mean, I think there is a lot of, disagreement between local authorities. I work with a lot of sub-regional choice-based letting schemes where they're doing very similar work to what Mary's described, collaborating together, meeting regularly, discussing how things should do. And when I come to rewrite policies for schemes, this becomes one of the most big talking points, or almost, there's a big camp that's in favour of the government's bedroom standard being used as the barometer for determining how many bedrooms a household should get. There's another big group of people that are really in favour of the DWP's definitions of how many bedrooms should be allocated to which person in which sets of circumstances. The DWP's arrangements are more generous than the bedroom standard, and depending on your supply and demand, on your perspective, again, on the efficacy of these policy positions, depends on which route people go down. If it was left to me in terms of writing a scheme set of rules, I would go with the DWP's arrangements, because I think they are more applicable to the intention of giving someone a bedroom in a home. Whereas the bedroom standard, which arises from overcrowding law, is a measure to determine whether someone has enough space for where they're currently living. So it's a useful measure, but I think the DWP's arrangements, and principally a lot of the difference between the two of them is entitlement to your own bedroom, which under overcrowding law is 21, and under DWP's rules is 16, which is a big difference. There are other nuances of differences between the two of them, but that's the big one. So if it was me, I would go with the DWP standards, but I see why people with stock pressures might look to a different arrangement. What I would do is use one of those two sets of measures and not create a third alternative arrangement, because that just becomes even more confusing.
Thank you. Mary, is there anything you wanted to add?
I should say I'm not particularly close to what arrangements are being used in each Greater Manchester local authority, so I wouldn't particularly want to comment on the detail of it. I think just something else to mention here is that we have a lot of pressure in Greater Manchester, as I'm sure you do elsewhere, in terms of the need for larger family housing in particular. So 4-5+ bedroom stock is very hard to come by. So that is something where those kind of, those clashes around bedroom standards definitely come into play. But I don't particularly have anything to add on that one. Becca, thank you.
A question for Charlotte. Charlotte is from Charlotte is, how do you ensure that direct lets are fair?
So sorry, Neil, do you want to?
No, go on, Mary.
I was just, so in the context that I mentioned direct lets, when we talk about this in Greater Manchester, generally speaking, those are related to kind of homelessness prevention schemes. So for example, Housing First, we have a pilot of Housing First in Greater Manchester currently, rough sleeping accommodation programme, and our some routes out temporary accommodation as well. So the way that those direct lets would be ensured would be fair would be that those people who are subject to those programs have already kind of met the criteria for the programs, and often the homes are identified to be part of that program. So for certain properties will come through for Housing First, for example, be identified for a sleeper accommodation program. So that would be the way that we would, I hope that answers the question from my side of what I mentioned in terms of that. Again, I can't speak to direct lets across the board, but in those instances that I was talking about, it's about ensuring that it's people who already meet the quite high need criteria of some of these programs, and identifying suitable properties for that group of people as well. Tends to be one bed accommodation.
I think, thanks, Mary. I think if you're going to use direct lets, then you have to have an evidence base as to why you're using it and why you're not using choice. Same the other way around. If you're going to use choice, you have to have an evidence base as to why you're using choice and not using direct lets. So principally, there needs to be an evidence base first and foremost. Secondly, if you're using direct lets in tandem with choice, and some people are given choice and some people are giving direct lets, you also then have to have an evidence to say, well, why are those people with those characteristics or those circumstances given direct lets and those other people being given choice? And if there's no rational evidence as to why some are given direct lets and why some are given choice, then you have to stop doing direct lets, because that's not fair. Principally, if there is an evidence base to say that some or all applicants should be given direct lets, then the demonstration of fairness is the evidence base itself, and particularly, again, is the guarantee that any offer made will be suitable. And if it turns out that the offer is not suitable, then we will withdraw that and you'll be given a different offer. So there's something about only doing direct lets or only doing choice, because there's an evidence base to say you should be doing one of those things or a combination of both, and where that, and so yeah, evidence-based policy and a reliance on a really strong suitability standard.
Thank you. And Paul, I did see you had your hand up. Has your question been answered, or would you like to ask it now?
It wasn't so much a question, it was more an observation, and it was relating to the discussion about limiting the number of reasonable offers to homeless applicants. In the sub-regional choice-based letting scheme we operate in, homeless applicants do only get one reasonable offer, and then if they refuse it, the homeless priority is withdrawn, which I always felt made me feel uncomfortable. However, speaking to applicants on a wider basis, they felt very strongly that homeless applicants, by being awarded the highest band in the whole system, had better opportunities than they did. So that was quite interesting to see it from somebody who was bidden, who wasn't in a homeless position. So I can sort of understand why they do restrict it. But I've got no answer, I have to say. I don't think there is a perfect answer to it.
Great observation.
Yeah, definitely. And a question from Sarah in the chat. We are finding affordable rents are massively problematic in some locations, as it's pushing households well into the benefit cap, and also that applicants under 25 on universal credit can't meet their basic needs due to deductions. Are there any policy suggestions regarding how to manage these scenarios?
Well, Mary might have some at GM level. I think more nationally, you obviously have to get permission from the regulator to allocate a property at an affordable rent rate. And so some of that is reviewing your existing evidence base to determine how many properties are being used at an affordable rent rate, and determining whether actually they need to be turned to a social rent rate. So again, it is evidence base that's driving policy, and practice needs to be reviewed. The challenge has been partly that a lot of the funding for the building of new social housing has been targeted at particularly affordable rent more than any other type of product. You know, whilst there's been funding for shared ownership and other low cost home ownership and and general needs. Just over the past 5 or 6 years, the building of all social housing has fallen, but particularly it's fallen for social rent down to just 6% of all new builds in the past 5 years. So it's a massive nationwide policy, and I think some of that again is about using your evidence through organisations like the NatFed and also through your own organisation, again to lobby policymakers nationally to say, well, affordable rent is a great part of a package, but actually it's not the whole package. We need more than that. So there's possibly no quick solutions. If someone is on an affordable rent tenancy and they can't actually afford it, then there's obviously exploring with them around what you can do around discretionary housing payments or other ways of helping them meet their rent requirements and other housing charges without resorting to eviction. But you've probably thought of some of that stuff already.
I mean, I would 100% echo Neil. I think so. In Greater Manchester, just for context, only 5 of our 10 local authorities are actually able to, under Homes England rules, develop new social rent housing. They because there is a limit on there needs to be at least a £50 rent difference between PRS between LHA rate and social rent for you to be able to develop social rent. And so only 5 of our local authorities that are seen as the least affordable get to that level. But we're actually finding that even in the areas that have traditionally been more affordable in Greater Manchester in recent years, that's not the case anymore, and private rents are really rocketing, and LHA isn't keeping up. So that's something where we're lobbying around kind of relaxation of the affordable homes programme rules, but also looking at kind of LHA rates and increasing those and increasing support. But yeah, I can't go into, I don't have any sort of detail of local policy responses to this, other than, as Neil said, reviews of where affordable rent is being charged when the property comes void. And I know there is some work on doing that, and also, you know, working to access things like discretionary housing payment as well. Obviously that's not a great solution to this issue, and it is something that we do lobby for, particularly allowing the building of new social rent in all of our areas, and adequate funding for that as well is something that we're very, very passionate about.
Thank you. And Mary, I've got a specific question for you again from Sarah, and said she might have missed this bit because they've had a bit of disruption in the connection. But does the allocation group link up with the housing enabling on new supply? She says in her experience, these two groups don't communicate enough.
Yeah, and I think that I would agree with that. I think that particularly given the way that local authorities are very big, complicated organisations, people who are responsible for both of those things may not sit in the same team. They may not know each other particularly well in one local authority, let alone across accommodation. So what the beauty of the network is that because it brings, so as I said, there is a challenge to this, but the fact that it brings together people who have mixed specialisms means that we do have some people who are working, who are, you know, they work on the allocation side, but also around kind of strategy around new build supply in local authorities. So one of our network members brought a presentation on work they've done. They've done basically some analysis of the data they hold in the housing register that's, you know, in a more detailed way to look at how they can, what their housing need is around new supply, how to get the best out of Section 106, and kind of pulling that through together for the next update of their local plan. So that's the first bit of work we've done, and we are intending to do this in a bit more formal way and have kind of a bit of a meeting with, there are some planning groups in Greater Manchester, and kind of getting together some members of the network and some members of those planning groups to almost start having those conversations to say, we, you know, people who work in allocations, and this is also in housing providers as well, hold really important information about need that goes much deeper than what you'll get from a desktop housing needs assessment. And we want to target some of this at looking at how we influence that new build supply, obviously within the restraint, you know, within the constraints of your local plan. But yes, that is, you know, that's one of the, I think it's one of the more exciting pieces of work we're doing. Everyone's very keen to get using that information that we have in a more targeted way. So obviously, you know, hopefully we can keep you posted on that one.
Thank you. And I mean, please keep your questions coming. And I was just going to say, Neil, I thought you explained the context and the legislation really clearly, but we can see that it's really complex, and that's something that's picked up in the NHF's research as well. Have either of you seen good examples of clearly communicating allocations and lettings policies to applicants? And perhaps if there's anything specific, then we can share them in the email that follows up from the workshop.
I think, so I think the legislation and regulations are complex, and there's more legislation than what housing associations might imagine there is. Local authorities benefit from 5 separate pieces of statutory guidance around the allocation of social rented housing. And there's no statutory guidance or even voluntary guidance for housing associations. So there's a big deficit there. Housing associations can read the local authority guidance, and a lot of it applies to them, but it seems to me that housing associations are deserving of their own guidance. Because housing is a devolved matter in Scotland, there is statutory guidance issued by the Scottish Government for the attention jointly of local authorities and housing associations. So they're both reading the same statutory guidance, they're both expected to do the same sorts of things. So that's quite useful. I think housing allocation policies themselves, they are a document that ultimately you'll be defending against yourself in court. So that they need to be framed in that way, you know, that effectively it's a legal document. So they're not always the most readable, user-friendly things. It's a great way to get yourself to sleep. But there should be user-friendly guides produced. I'm writing one for a local authority at the moment. One of my favourite user-friendly guides of allocations policy and practice is actually produced by Age UK, which is not about a particular local authority areas guide, but just generally how housing allocation should work. Obviously targeted towards older people, but actually it's written really, really well, and what they're saying in it really would apply to anyone with any circumstances or characteristics. So Age UK have got a really nice piece of work there that anyone could use and share in its format now, or use to inspire your own local stuff.
And yeah, from my side on that, thinking about kind of communicating allocations policies to prospective tenants, to residents of Greater Manchester, is something that we've put quite a lot of thought into, because the part of where this work came from was questions from kind of councillors, elected members, people in the system, as to why those housing, that shot I showed you of the different housing registers, why do those look so different in each local authority? There doesn't seem to be much of a pattern. Why is this the case? So we almost wanted to produce something that would give an overview of housing allocations in the local authority. So we produced a paper that talked quite generally about housing allocations, and then gave some of the differences between local authorities and Greater Manchester. Within that piece of work, though, we were also looking for examples from local authorities. So one of our local authorities has written kind of a plan on a policy on a page, if you will, which is very difficult to do, but they've produced that, and I'll speak to contact there and see if I'm able to share that, because that's a really useful document. But we're aware this is an area that we could do more on at Greater Manchester level, in terms of kind of having clear communication of what your policy is and what it's trying to do, and that having some consistency across Greater Manchester would be very helpful. So yeah, but I will see if I'm able to share that example with you as well.
I like the policy on the page. I think that's great. Something to remember when writing for anybody in the public is that for every 100 words, it doubles the pressure on your brain, and it makes it harder to understand it. So if you can say all of it in 100 words, which clearly you can't with social housing allocations, that's brilliant. But if you can say the most important things in the first 100 words, that's really important. And actually, most people stop reading after 10 words. So say what you really need to say in the first 10, say the second most essential stuff in the first 100, which is going to be your first paragraph or so. And after that, people, only the most enthusiastic are reading after that. So the policy on the page stuff is a great aspiration.
10 words, wow. I have so also thinking about partnership working now, and when you think about allocations and lettings, which sticking points in the process do you think could be resolved through closer partnership working between local authorities and housing associations? Hand over to Neil first.
I think almost all of them. I know sub-regional partnerships are a real bane of people's lives, and I know some have decided to cease being in partnership in recent years, and I'm sure there's good reasons for that. But I was around at the then DCLG when we had a target to have a sub-regional choice electing scheme across the whole of the country by 2010, and worked with local authorities to almost make that happen entirely. And the choice with elections is a bit like public transport systems, and we're at Greater Manchester. We've got Mary from Greater Manchester here, so that's a great example. You know, you've got across Greater Manchester a Metrolink tram system that's got 100 different stations at it. And imagine if, as you went from Manchester to Salford and Salford into Trafford, you had to get off and buy a new ticket because you'd gone into a new local authority area. It would just drive you nuts. And yet with allocations, and there have been attempts in Greater Manchester, and I won't go into the dark, sordid details, but there's been attempts in Greater Manchester to have a single allocation scheme for Greater Manchester, and it wasn't successful. There is a single allocation scheme in other areas, such as Merseyside, and from applicants' point of view, and this is what we have to remember, allocations is about applicants and your properties, but applicants equally, people and properties in equal measure. People like common allocation schemes. They like a single register. They like a single set of rules for prioritisation. They don't see the local authority boundaries. They're not interested in local authority boundaries. They want a consistent way. So schemes work best from an applicant's point of view, where there's a single application form across a geography and a single set of rules for determining who's prioritised and who's qualified and disqualified. Where that doesn't happen is because local authorities and housing associations disagree on the issues of prioritisation and qualification, and I think we have to come together to bridge those disagreements. And I would say common allocation schemes on a local authority area are better than non-common schemes. Common schemes on a sub-regional basis are better than a non-sub-regional basis. So I would continue to strive to make those common schemes work, and to do the stuff that Mary's doing. If you can't have a common scheme, then at least do the stuff that Mary and her colleagues are doing in Greater Manchester.
Well, I mean, thanks for that, Neil. We're trying, and there was, yes, to be fair, there were conversations about a single allocation scheme a number of years ago, and for many different reasons that isn't going to be the case in Greater Manchester. We do find that, so an example being Manchester has a common allocation scheme called, and it's Manchester Move, and all of the housing providers pretty much all the housing providers in Manchester are signed up to Manchester Move, and they tend to find that works better. They have a Manchester Housing Partnership Board that then meets with all the providers, and the council can meet to discuss those issues. And I think that, you know, some of the themes that we've got on our list of priorities for our allocations network: nomination agreements, local lettings policies, putting in place suitable mitigations that mean that tenancies are sustained if we're working with people where there may be issues sustaining tenancies. I think those are the areas that where we've seen partnership working can actually make a really big difference, and just having somebody that you can talk to on a case-by-case basis, even if it at a strategic level it's important to do it, but also having those relationships locally is very important. So I'd agree with Neil that almost every single point of contention, it's important to have strong partnerships, and they can be overcome, and these things can happen. But yeah, so.
Thank you. And just a quick final question, or perhaps not. What is a question from Sarah? What is the one thing that you think housing associations should stop doing? What would you like housing associations to stop doing?
I saw this flash up on the screen, and it's a great question. I'm going to be cheeky and do an interlinked two-part thing, but I'll be quick. Definitely stop asking for rent in advance, because it drives up inequalities and poverty, and there's a huge evidence base of that. And whilst you might not be the decision maker in your organisation that can make the decision to stop asking for rent in advance, speak to the decision maker and talk about it, and have an organisational review of that. And links to that: be better at how you conduct affordability assessments, and follow the advice I've shown in the slide, and be aware that there is case law from the Supreme Court that requires you to consider some stuff in affordability assessments, and therefore you must consider that proportionally. So all the financial side of an application to be reconsidered and looked at better.
I'm going to cop out and say I don't have an answer to what I think housing associations should stop doing. I just think that what we like our colleagues to keep doing and start doing, if not, is just talking to local authorities and being open to that partnership working, I think is the most important thing from my perspective. So yeah, I that would be my answer there. Thanks.
Well, thank you so much, everyone, for coming, but also a huge thank you to Neil and a massive thank you to Mary. It's just been brilliant to have you and have you share your insight, experience, just such a huge level of information. I also wanted to draw attendees' attention to the fact that the NHF is collaborating with Crisis and the Centre for the UK Collaborative Centre for Housing Evidence, CASH, on a survey of housing association allocations practice. So Susanna's just put a link in the chat there. We're really excited about this collaboration because it's the first opportunity for housing associations to share their experience around allocations, and we're really keen that you contribute to the research because it's the local authorities get asked this quite a lot. The DLUC have done the research, but they're not publishing it, so it's a really good opportunity. So be grateful if you could take part. But we'll be sharing all the slides and recording and the guidance that you have requested. But thank you so much again for coming, and thank you to Neil and Mary. It's been great.
Thank you very much.
Thank
Bye-bye.
you. Bye bye.
Thank you.
Bye.
Thank you. Bye.
Thank you.
Bye.